Yung subtopic ay Special Corporations. In this particular chapter sa Corporation Code, tatlo yung special corporations: educational, religious, and one-person corporation. Yung one-person corporation, isa yan sa major innovations sa revised Corporation Code. I-discuss natin yan later. Number 1, educational corporations. Trustees of educational institutions organized as non-stock corporations, non-stock, shall not be less than 5 nor more than 15. Nor more than 15. If you can still remember, yung non-stock corporations generally may or may not be more than 15 trustees. So, maybe more than 15 trustees. Pero kung yung non-stock corporation ay educational, dapat not more than 15. The number of trustees shall be in multiples of 5. So, 5, 10, or 15 yung number ng trustees. Hindi pwede yung 6, 8, 11, or 14. So, multiples of 5. 5, 10, or 15. Unless otherwise provided in the articles or bylaws, the Board of Trustees of incorporated schools, colleges, or other institutions of learning shall, as soon as organized, so classify themselves that the term of office of 1/5 of their number shall expire every year. 20% or 1/5 dapat nag-expire every year. So if there are 5 trustees, dapat every year isa sa mga trustees nag-expire yung term. 20%. If there are 10, then 2 yung mag-expire yung term. Trustees thereafter elected to fill vacancies occurring before the expiration of a particular term shall hold office only for the unexpired period. Trustees elected thereafter to fill vacancies caused by expiration of term shall hold office for 5 years. Generally, yung term of office ng trustee ng non-stock corporation ay 3 years. Pero dito, 5 years. Pag-start ng corporation, ito yung mangyayari. Say there are 5 trustees, A, B, C, D, E. 5 trustees. Dapat, every year, mag-expire yung term ng isang trustee. Ito, 1 year yung term, 2 years, 3 years, 4 years, 5 years. After 1 year, mag-expire yung term ni A. At kung sino yung papalit kay A, will have a term of 5 years na. After another year, mag-expire yung term ni B. At kung sino yung papalit kay B, will have a term of 5 years na. And so on. So every year, merong nag-expire na term. 1/5 or 20%. A majority of the trustees shall constitute a quorum for the transaction of business. The powers and authority of the trustee shall be defined in the bylaws. Next page. For institutions organized as stock corporations, the number and term of directors shall be governed by the provisions on stock corporations. So yung ating educational corporations may be non-stock, or maybe stock corporations. Kung stock corporation siya, yung rules na go-govern sa kanya or provisions ay yung provisions tungkol sa stock corporations. Number 2, religious corporations. Religious corporations may be incorporated by one or more persons. One or more persons. They may be classified into corporation sole or religious societies. Yung one, yan yung corporation sole. Yung corporation sole, iba to sa one-person corporation. Yung religious societies, ito yung more. Ito yung parang general rule, exception yung corporation sole. A corporation sole may be formed by the chief archbishop, bishop, priest, minister, rabbi, or other presiding elder of a religious denomination, sect, or church for the purpose of administering and managing as trustee the affairs, properties, and temporalities of the church. So, si religious leader, kung mag-i-incorporate as corporation sole, siya yung corporation sole. Pero hindi ibig sabihin na siya yung owner. Siya ay trustee lang. Tagapag-administer or manage ng affairs, properties, and temporalities of the church. Yung mga funds ng church. If he retires, yung bagong religious leader, yan na naman yung papalit sa kanya as the new corporation sole. Yung next paragraph, unique feature to ng corporation sole. Kung tanungin tayo, when does a corporation acquire juridical personality? Kailan nagkakaroon ng juridical personality? Very basic na tanong. From the time of issuance of certificate of incorporation by the sect. Pero dito, iba yung rule. When does a corporation sole acquire juridical personality? Sabi ng law, from and after filing with the sect of the articles of incorporation, the chief archbishop, bishop, or priest shall become a corporation sole. So, from and after filing with the sect of the articles of incorporation. The approval of the sect is not necessary, and the issuance of a certificate of incorporation sole to acquire a separate juridical personality is not required. So, exception to the rule to. Number 3, one-person corporation. As I mentioned earlier, isa to sa major innovations sa revised corporation code. One-person corporation, pero hindi to single proprietorship. Mamaya, i-distinguish natin yan. Hindi to single proprietorship. A one-person corporation is a corporation with a single stockholder. So, isang stockholder lang. Only a natural person, trust, or estate may form a one-person corporation. Natural person, hindi yung juridical persons like partnership or corporation. So, yung partnership, hindi pwedeng maging single stockholder ng one-person corporation. Yung corporation also, hindi pwedeng maging single stockholder ng one-person corporation. Pero yung trust or estate, pwede. Yung trust, parang agreement yan. Merong trustor, trustee. Ini-entrust ng trustor kay trustee yung administration ng property, say for the benefit of the beneficiary. Merong trust. Yung trust tinitreat na parang tao, pero in a limited sense lang. Limited para lang sa trust. Para lang sa administration ng property for the benefit of the beneficiary. Yung trust sa income tax law, tinitreat to na parang tao din. Kasi kung merong income yung trust, siya yung magre-report ng income niya. So the trust as the income taxpayer. So tinitreat siya na parang tao. Dito yung trust, pwedeng maging single stockholder ng one-person corporation. Yung estate, pwede rin. Ano yung estate? Say namatay yung tao, date of death, date of settlement ng estate. Yung settlement, ito yung dinistribute na sa heirs, yung properties. So habang hindi pa na-distribute, meron tayong tinatawag na estate. Yung estate, ito yung properties left by the decedent. Say, estate of the decedent. Tinitreat siya na parang tao din. Sa income tax law, kung merong income yung estate, siya din yung magre-report ng income. The estate as the income taxpayer. Pero yung personality niya, limited sense din. Estate, pwedeng maging single stockholder ng one-person corporation. Banks, quasi-banks, pre-need companies, trust companies, insurance companies, public and publicly listed companies, non-chartered government-owned and controlled corporations may not incorporate as one-person corporation. Next page. A natural person who is licensed to exercise a profession may not organize as a one-person corporation for the purpose of exercising such profession except as otherwise provided under special laws. So yung practice of profession or exercise of profession, hindi pa rin pwede yung corporation. So, pwedeng single or partnership. Pero hindi pwede yung corporation. Kahit na one-person corporation yan. Minimum capital stock required for one-person corporation. Yung revised corporation code does not provide for minimum authorized capital stock. Nawala na yung 25% requirement. So, walang minimum. More so, dito sa ating one-person corporation, wala na rin yan. A one-person corporation shall not be required to have a minimum authorized capital stock except as otherwise provided by special law. Articles of incorporation. A one-person corporation shall file articles of incorporation in accordance with the requirements under Section 14 of the Corporation Code. Doon sa topic na incorporation, nandun yung contents ng articles as provided under Section 14. Dagdagan lang natin nito. It shall likewise substantially contain the following. If the single stockholder is a trust or an estate, the name, nationality, and residence of the trustee or administrator or executor or guardian or conservator, custodian, or other person exercising fiduciary duties together with the proof of such authority to act on behalf of the trust or estate. Letter B. name, nationality, residence of the nominee, and alternate nominee. Yung nominee and alternate nominee will be discussed later. Yung role nila para merong continuity. If something happens to the president, to the single stockholder, sila yung papalit para merong continuity. So, hindi siya madidissolve. Unlike kung single proprietorship, pag namatay yung owner, mawawala na yung business. Pero ito, kahit namatay si single stockholder, nandyan pa rin si corporation. Ko-continue yan. At merong proseso. Si nominee or alternate nominee, temporary lang yung pag-assume nila ng power doon as director para tatakbo lang yung corporation. And the extent, coverage, and limitation of the authority. Next page. Bylaws. The one-person corporation is not required to submit and file corporate bylaws. So, bylaws, not required. Display of corporate name. A one-person corporation shall indicate the letters OPC, either below or at the end of its corporate name. Yung purpose niya, parang sa limited partnership, gagamit ng limited na word or LTD sa kanyang pangalan to forewarn the party transacting with the partnership that it is transacting with a limited partnership, not a general partnership. So dito, parang ganyan din to forewarn the party transacting with the one-person corporation that it is transacting with a one-person corporation. Single stockholder as director and president. So si single stockholder, automatic na yan, director and president. The single stockholder shall be the sole director and president of the one-person corporation. Siyempre, wala nang mga elections dito, walang meetings kasi single stockholder lang. Treasurer, corporate secretary, and other officers. Mga officers ng corporations. Within 15 days from the issuance of its certificate of incorporation, the one-person corporation shall appoint a treasurer, corporate secretary, and other officers. Take note of the word appoint. Walang election dito Appoint lang as it may deem necessary and notify the SEC thereof within 5 days from appointment. The single stockholder may not be appointed as the corporate secretary. So, si single stockholder na siya yung president, bawal na maging secretary at the same time. May not be appointed as the corporate secretary. So, yung bawal lang dito, yung president and secretary at the same time. Pero yung president and treasurer at the same time, pwede. Next paragraph. A single stockholder who is likewise the self-appointed treasurer. So ito yung single stockholder na president, director, na treasurer din. Self-appointed treasurer shall give a bond to the SEC in such a sum as may be required. The said stockholder treasurer shall undertake in writing to faithfully administer the one-person corporation's funds to be received as treasurer. And, next page, to disburse and invest the same according to the articles of incorporation as approved by the SEC. The bond shall be renewed every 2 years or as often as may be required. special functions of the corporate secretary. In addition to the functions designated by the one-person corporation, the corporate secretary shall, ito yung functions provided for by law, be responsible for maintaining the minutes, book, and or records of the corporation. Yan naman talaga yung ginagawa ng corporate secretary. Keeper of records. Yung letter B hanggang letter D, parang ito yung role ng corporate secretary kung merong succession. Ano yung mangyayari if the single stockholder becomes permanently incapacitated or dies? What will happen? Letter B, notify the nominee or alternate nominee of the death or incapacity of the single stockholder, which notice shall be given no later than 5 days from such occurrence. Letter C, notify the SEC of the death of the single stockholder within 5 days from such occurrence, and stating in such notice the names, residence addresses, and contact details of all known legal heirs. Call the nominee or alternate nominee and the known legal heirs to a meeting and advise the legal heirs with regard to, among others, the election of a new director, amendment of articles, and other ancillary and or consequential matters. So parang yung, kung titingnan natin yung B, C, D, sa succession yan. Nominee and alternate nominee. The single stockholder shall designate a nominee and alternate nominee who shall, in the event of single stockholder's death or incapacity, take the place of the single stockholder as director and shall manage the corporation's affairs. So, sabi niya, or sabi ng law, as director. Papalit siya doon, as director. Hindi sinabi ng law, as president and director. Director lang. Ha? Next page. The articles of incorporation shall state the names, addresses, and contact details of the nominee and alternate nominee, as well as the extent and limitations of their authority in managing the affairs of the one-person corporation. So, nakalagay sa articles yung extent and limitation sa authority. The written consent of the nominee and alternate nominee shall be attached to the application for incorporation. Such consent may be withdrawn in writing anytime, withdrawn, before the death or incapacity of the single stockholder. Term of nominee and alternate nominee. Kung papalit siya doon as director, hanggang kailan? When the incapacity of the single stockholder is temporary, the nominee shall sit as director and manage the affairs of the one-person corporation until the stockholder, by self-determination, regains the capacity to assume such duties. So, until the stockholder, by self-determination, regains the capacity. In case of death or permanent incapacity of the single stockholder, the nominee shall sit as director and manage affairs of the one-person corporation until the legal heirs of the single stockholder have been lawfully determined, and the heirs have designated one of them or have agreed that the estate shall be the single stockholder of the one-person corporation. The alternate nominee shall sit as director and manage the one-person corporation in case of the nominee's inability, incapacity, or death or refusal to discharge the functions as director and manager of the corporation. So, yung paragraph na to talks about alternate nominee. And only for the same term under the same conditions applicable to the nominee. Next page. Change of nominee or alternate nominee. The single stockholder may at any time change its nominee and alternate nominee by submitting to the SEC the names of the new nominees and their corresponding written consent. For this purpose, the articles of incorporation need not be amended. So, no need to amend kasi mahabang proseso pa yung amendment ng articles. Minutes book. A one-person corporation shall maintain a minutes book which shall contain all actions, decisions, and resolutions taken by the one-person corporation. Records in lieu of meetings. So, walang meetings dito dahil single stockholder lang to. At sole director, mag-isang director lang. No? When action is needed on any matter, it shall be sufficient to prepare a written resolution signed and dated by the single stockholder and recorded in the minutes book of the one-person corporation. The date of recording in the minutes book shall be deemed to be the date of the meeting for all purposes under this code. Reportorial requirements. The one-person corporation shall submit the following within such period as the Commission or the SEC may prescribe. Next page. Annual financial statements audited by an independent CPA. Audited FS. If the total assets or total liabilities of the corporation are less than 600,000, the financial statement shall be certified under oath by the corporation's treasurer and president. A report containing explanations or comments by the President on every qualification, reservation, or adverse remark or disclaimer made by an auditor in the latter's report. So, explanations on the disclaimer or adverse remark by the auditor. A disclosure of all self-dealings and related party transactions entered into between the one-person corporation and the single stockholder. So, self-dealings between a one-person corporation and the single stockholder kasi magkaiba yung personality. Si OPC has a different personality than a single stockholder. Although si single stockholder, siya yung parang owner ni OPC, pero magkaibang personalities. Other reports as the Commission may require. For purposes of this provision, the fiscal year of one-person corporation shall be that set forth in its articles, or in the absence of the calendar year, kung silent. The SEC may place a corporation under delinquent status. Take note, delinquent status. Should the corporation fail to submit the reportorial requirements 3 times consecutively or intermittently within a period of 5 years. So, consecutive, tuloy-tuloy, or intermittent within a period of 5 years. Liability of single stockholder or shareholder. A sole shareholder claiming limited liability. So, parang corporation pa rin, na yung stockholder is liable only to the extent of his contribution. to the extent of his investment. So limited liability. A sole shareholder claiming limited liability has the burden of affirmatively showing that the corporation was adequately financed. Where the single stockholder cannot prove that the property of one-person corporation is independent of the stockholder's personal property, the stockholder shall be jointly and severally liable or solidarily liable for the debts and other liabilities of the one-person corporation. Next page. The principles of piercing the corporate veil applies with equal force to one-person corporation. So, subject din siya sa the same rule about the piercing the veil of corporate fiction. Conversion from an ordinary corporation to a one-person corporation. So, ordinary to one person. When a single stockholder acquires all the stocks of an ordinary stock corporation, the latter may apply for conversion into a one-person corporation subject to the submission of such documents as the SEC may require. If the application for conversion is approved, the SEC shall issue certificate of filing of amended articles reflecting the conversion. The one-person corporation converted from an ordinary corporation shall succeed the latter and be legally responsible for all the latter's outstanding liabilities. So, a-assume niya yung lahat ng liabilities ng ordinary corporation. Conversion from one-person corporation to ordinary stock corporation. A one-person corporation may be converted into an ordinary stock corporation after due notice to the SEC of such fact and of the circumstances leading to the conversion, and after compliance with all other requirements for stock corporations under the Corporation Code and applicable rules. Such notice shall be filed with the SEC within 60 days from the occurrence of circumstances leading to the conversion into an ordinary stock corporation. If all requirements have been complied with, the SEC shall issue an amended certificate of incorporation reflecting the conversion. Next page. In case of death of single stockholder, the nominee or alternate nominee shall transfer the shares to the duly designated legal heir or estate within 7 days from receipt of either an affidavit of heirship, yung mga documents, or a deed of self-adjudication executed by the sole heir or any other legal document declaring the legal heirs of the single stockholder and notify the SEC of the transfer. Within 60 days from the transfer of shares, the legal heir shall notify the SEC of the decision to either wind up and dissolve the one-person corporation or convert into an ordinary stock corporation. The ordinary stock corporation converted from a one-person corporation shall succeed the latter and be legally responsible for all the latter's outstanding liabilities. So, assume niya rin yung lahat ng liabilities. That ends special corporations.